Robert Krajcik, Ottawa, Ontario, Rebel News. Day 25 of the trial of Chris Barber and Tamara Lich has just come to an end. Both co-defendants are being charged with a series of crimes linked to their roles as organizers in the Freedom Convoy of 2022. That was a large, peaceful demonstration. It was civilly disobedient here in downtown Ottawa, and it was broadly opposed to what I refer to as the COVID-19 enterprise, a series of edicts, mandates, decrees, lockdowns, all ostensibly issued by different levels of government in order to protect public health in the context of COVID-19 transmission. We got to speak with Lawrence Greenspan, defense attorney for Tamara Lich. We're also going to speak with a lawyer and get his insights into today's proceedings. But before we go there, I want to remind you folks that we need your financial support to continue our operations for this in-the-field journalism. Please visit tamaratrial.com and stay up to date with our ongoing coverage. Can you tell us anything about what was disclosed in the document list that the judge determined yesterday would be disclosed? The contents of that disclosure.
We received a copy of what was referred to as Exhibit A, and we intend to make use of at least some of it in the upcoming cross-examination of Officer Bache. That's about as much as I can tell you at this point.
And now with the pending dispute that you had where you were spending some time today speaking with the prosecution, was there any resolution reached there, or will this then be put to the judge to make her determination over whether or not to review, whether or not to disclose, if at all?
Well, there's still a pending application that the judge needs to determine as to solicitor-client privilege of some documents. And aside from that, there's still an issue of which of the chats are going to be tendered by the Crown. And Ms. Magus is trying to work that out with them, but I suspect that ultimately the judge may have to rule on at least some of those chats.
One more question then. With the solicitor-client privilege disclosure dispute, the judge right at the end of today's proceedings said that she would decide whether or not to reveal some or all. Am I inferring too much in there? Because she didn't acknowledge that she can also choose to maintain all redactions. Did you catch that?
Yes, I caught it, and I think you're inferring too much.
Okay.
She may release some or all or none, and she knows that, and I think we'll have to wait for that decision.
And lastly, in terms of the theme of some of the cross-examination you did today with the Ottawa Police Service officer, I saw a theme of demonstrating that there were several convoys and several leaders. Can you elaborate on the purpose of that demonstration?
Well, it's been the evidence so far that there were multiple demonstrations, multiple convoys, so to speak, and we're looking at numerous organizers of the different convoys that were in town over the period of time. So it's what I wanted to establish was that despite all of that, this PLT officer, having had communication interactions with hundreds of protesters, demonstrators, and other people, that there was, despite that, no note anywhere of anyone who said, yeah, I'm here because of Tamara, or yeah, I'm here because of Chris Barber.
I'm here with Adam, my favorite lawyer right now from the Democracy Fund. Adam's been in the proceedings all day. We were speaking earlier about cross-examination of the witness from today. It's an Ottawa police officer. His name is Jordan Blondie. And he worked with the police liaison team. That's a team in the Ottawa Police Service that works with stakeholders and events. In the context of this trial, the PLT worked with Chris Barber, corresponded with him, coordinated with him, and presumably Tamara Lich. So in the cross-examination, Adam, you mentioned that there were some seeming contradictions. Can you elaborate on that and tell our audience what you saw?
Sure. So it came out in Cross that Mr. Officer Blondie believed that as of February 12th of 2022, he observed a number of different convoy protests. I think the direct quote was, too many to count, and it was a point of confusion. Then later on, he said that, however, as of today, looking back on it, he viewed it as a single protest, a single group, and he said they were unified largely by their shared belief system. I think the issue that arises there, and sort of the contradiction, it looks like a contradiction. The issue that arises there is the Crown is trying to show that Mr. Barber had control over the convoy in its entirety. If he's saying on February 12th that there were a number and too many to count, too many different convoys to count, that would be, for the Crown, seemingly much more difficult to make out that the elements of an offense that would relate to him being the leader of the convoy.
So 2 quick follow-up questions. Just as a general theme, when it comes to witnesses that may issue contradictory statements, at least with respect to their current testimony versus what they may have said previously on record, does that undermine credibility possibly in the minds of a judge?
Sure, of course. I mean, anything that looks to be contradictory will be taken in and reviewed by the finder of fact. She's going to have to see if that will impact, his statements one way or the other. It's something she's going to have to consider, most certainly.
So one other observation that you made, an astute one, was something the judge said towards the end of the day's proceedings regarding an ongoing disclosure dispute regarding solicitor-client privilege over certain email chains between the Ottawa Police Service. Can you tell our audience what it was that you caught?
Yeah, so I found it interesting. She said that the question that needs to be answered on Friday when she renders her decision is whether some or all of the solicitor-client claimed privilege by the Crown, redacted portions of the email, are going to be disclosed. She didn't seem to comment on whether the option of the redactions being kept intact were still on the table.
So we still have 2 pending disclosure disputes between the prosecution and the Crown. The first one is regarding what we've reported on before regarding these emails between Ottawa Police Service officers that are redacted by the prosecution via the Ottawa Police Service because the Crown claims that these are privileged communications that should be protected via solicitor-client privilege. Now, the judge has accepted that claim with one massive caveat. She will review those emails and determine for herself what, if any, or all of the contents of those emails can be revealed to the defense teams. To remind you folks from what happened yesterday, the challenge here against this disclosure was that none of these emails involve actual lawyers. In other words, no lawyers were either senders or receivers of these emails. So the defense challenged, how can there be solicitor-client privilege, which protects communications where lawyers provide guidance to their clients, if there are no lawyers providing guidance directly in those emails? But the Crown argued, and the judge accepted, that these emails contained counsel provided by the Ottawa Police Service Legal Department to a series of police officers in the context of testifying in this trial. In so doing, it was this sort of indirect application of solicitor-client privilege, which again, the judge will review and likely, we expect, render her decision over what to disclose, if anything, this coming Friday when the trial resumes. A second disclosure dispute also involves documents related to the Ottawa Police Service. So the Ottawa Police Service, the OPS, has this section known as the Police Liaison Team, the PLT. The PLT corresponds with stakeholders in special events, as they call them. In the context of this trial, that refers to their communications with organizers of the Freedom Convoy, specifically Chris Barber and presumably Tamara Lich. They coordinate, communicate with these organizers to pursue what they call public safety as their mission. Now, These OPS PLT officers use Signal to communicate with one another via text chat, and something like 1,100 plus pages of these Signal chat logs are being sought by the two defense teams to be fully disclosed. Some portion of these text logs are redacted, and the defense wants them fully disclosed. There was a period of the day where for several hours, both the prosecutors and the defense teams were negotiating between themselves outside of the courtroom, seeking to resolve this between themselves. But they couldn't really reach a resolution, and Lawrence Greenspan, defense attorney for Tamara Lich, said that this dispute will likely go to the feet of the judge, who will render her decision. And when this dispute is presented to her, when these chat logs are presented to her, she will have the option of either reviewing them or not reviewing them and maintaining the existing redactions. If she does review them, she can maintain all redactions, remove some of the redactions, or remove all of the redactions and give full disclosure. So we'll likely see some decision on that, we expect, this coming Friday when the trial resumes. The third event, the last part of the day, was questioning and cross-examination of an OPS officer who works with the PLT. His name is Jordan Blondie. Lawrence Greenspan and Marwa Yunus, who was a co-counsel for Chris Barber, sought to demonstrate that the Freedom Convoy itself was decentralized. They yielded testimony from Blondie in which he acknowledged several times that there were several organizers or leaders of this convoy, and that the convoy itself could not exactly be viewed as one convoy, but multiple convoys. Now, why is that important? Because the defense is seeking to demonstrate that Chris Barber and Tamara Lich cannot be viewed as singular leaders of this convoy or these convoys, and therefore the arguments made by the prosecution that it was specifically controlled, the Freedom Convoy, by the two co-defendants is therefore undermined. One more thing jumped out at me that will connect to something that I highlighted, I think, in the first week of this trial, and it was an acknowledgement by Jordan Blondie that the removal of discretion on the part of the PLT to negotiate with the Freedom Convoy organizers undermined the PLT's ability to reduce the impact of the Freedom Convoy demonstration on Ottawa. Specifically, the PLT wanted to make overtures to the Freedom Convoy to consolidate their presence of vehicles, to reduce their footprint, that's the language they use, of the vehicles, of the motorists involved with the protest onto fewer and fewer streets, to reduce that impact of congestion upon Ottawa residents who were living around or working around the area of the demonstration. So we saw that in the first week. The top PLT officer, his name is Lucas Russell. His official title is Incident Commander. Again, the top PLT officer. He testified that he was told that not 1 inch, that's a quote, should be yielded to the Freedom Convoy, who was told that by his supervisor. But I will speculate, I will wonder how high up the food chain, how high up the chain of command did that order originate from? Did it come from Mayor Jim Watson? We can ask that question because the Ottawa Police Chief is subordinate to the mayor of the city. Anyways, that's an open-ended question. Maybe we'll get an answer to it. One last interesting aspect of this not 1 inch component that we saw revisited today is that we have testimony that confirms from several OPS PLT officers that their inability to negotiate, the removal of their discretion to make offers to the Freedom Convoy to consolidate the vehicle footprint and reduce the impact of the demonstration on Ottawa residents, was undermined by Ottawa's city management. So the very bureaucrats and politicians that are out there every day during the Freedom Convoy telling people that this is a siege, this is an occupation, and it's their top priority to end it as soon as possible, their own directives down the food chain to the OPS compromise that very objective. Dear Rebel News audience, in order for us to continue delivering this in the field, on the ground reporting to you, we need your financial support. So please visit tamaratrial.com and help us if you can, and also stay up to date with our ongoing coverage.